Good morning, everyone. Before I officially call our hearing to order, I just want to check in with my court report and make sure we're ready to go. Tracy?
Good morning. I'm ready to go. Afternoon.
Yeah, good afternoon. All right, now calling proceeding number 24AL-0397T. It is December 9th, 2024 at 1:00 p.m. This is a pre-hearing conference that was scheduled by decision number R24-0830-I in the matter of the advice letter number 3169 filed by Qwest Corporation doing business as CenturyLink QC Colorado to add additional services and features. I will refer to Qwest Corporation as just Qwest moving forward in this hearing. My name is Melody Mirbaba, and I am the administrative law judge who was assigned to hear this case. Consistent with commission practice, we are webcasting and recording this proceeding, and we have a court reporter taking down everything that's being said. If we do take any recesses, the webcast will continue, and that includes the video and audio. So please do keep that in mind. To make sure that we maintain a clear record, I'm going to ask everyone to keep their microphones muted until it is your turn to speak. I'd like to get started by finding out who we have here today. Let's take entries of appearance. I'd like to start with Qwest.
Good morning, Your Honor, or good afternoon, and everyone. Richard Corbetta, I'm appearing on behalf of Qwest, and Tim Kunkelman is with us as well.
Thank you. On behalf of the Boulder Regional Emergency Telephone Service Authority, the El Paso Teller County Emergency Telephone Service Authority, and the Douglas County Emergency Telephone Service Authority, who I will collectively refer to as the BED authorities.
Joseph Benkert, also on the call is co-counsel Bart Miller, and from Brett's Principal Patty West.
Okay, thank you. On behalf of the Colorado Public Utilities Commission staff, who I'll refer to as staff.
Good afternoon, Your Honor. Assistant Attorneys General Justin Cox and Josh Horman on behalf of trial staff of the Public Utilities Commission. We also have with us today Jennifer Kirkland from staff.
Thank you. On behalf of the Larimer County Emergency Telephone Authority, who I'll refer to as LETA.
Good afternoon, Your Honor. Tracy Oldemeyer appearing on behalf of LETA.
Thank you. On behalf of the Adams County E91 Emergency Telephone Service Authority, the Arapahoe County 911 Authority, and the Jefferson County Emergency Communications Authority, who I will collectively refer to as the AAJ authorities. We'll come back to the AAJ authorities. I do see we've got somebody who is attempting to connect right now. On behalf of the Colorado Council of Authorities, Inc., who I'll refer to as the CCOA.
Your Honor, this is Tracy Oldemeyer, and I also represent CCOA.
I just want to give a moment here to see if we've got some technical difficulties that we need to work out for the AAJ authorities.
Good afternoon. This is Brian Tharp. Can you hear me?
Yes, now I can hear you.
Sorry. Yeah, I'm on behalf of Adams, Arapahoe, and Jefferson County 911.
All right, great. We've got everybody who has filed either an intervention or a request to intervene in this case present. So before we move on to talking about the schedule to move things forward, I just want to address two things. And one is just I want to make a finding on the record today that Qwest has complied with decision number R24-0830-I by having counsel enter an appearance by the established deadline. I'd also like to briefly address the interventions that have been filed, starting with staff's. Given that commission's rules allow staff to intervene as of right in any commission proceeding, I find that staff's intervention is proper. Staff is acknowledged as a party to this proceeding. Turning to the remaining interventions, I find that they are all unopposed. And for that reason, and for those stated in the interventions, I will grant all the requests to permissively intervene. I will include a little bit more detail in my written decision on both of these matters, and that written decision will be combined with the decision that comes out based upon whatever we decide during this hearing today. Now that we have the parties established, I'd like to turn to the procedural schedule. And first, I'd like to hear from Qwest as to whether any agreements have been reached, and particularly whether Qwest intends to file an amended advice letter with a new effective date.
Thank you. So to answer the second question first, yes, Qwest does intend to file an amended advice letter with an amended effective date. I think likely the amended date will or may at least flow from the procedural schedule that we come up with today. So I don't know that we have a specific date, but I can tell you that the company does intend to file an amended advice letter, and the parties were advised of that last week. To answer your first question concerning a procedural schedule, I can tell you that we tried. There was a healthy email exchange last week proposing schedules, and generally speaking, based on Your Honor's suggestion of a May hearing, Qwest initially proposed a schedule that, and I won't go specifically into all the dates, but generally work backward from that with starting with initial testimony in March and working our way forward. The discussion was not contentious or in any way unprofessional, but different thoughts emerged during that discussion. And I won't speak for the other parties, but staff in particular proposed a slightly revised schedule, moving things up. And LIDA and the company are involved in a separate case, which has a more or less overlapping schedule. And I know Ms. Oldmeyer has some thoughts on that. And in addition, Bretza et al. Has some procedural issue they would like to raise. And based on that, we had a amicable discussion, but did not come up with a consensus schedule.
Okay, so I'll say typically I need to know what the effective date of an amended advice letter is going to be before establishing a schedule, because everything flows from that date. That date is essentially the deadline by which the commission has to issue a final decision. I take that date, I determine when I have to issue my decision by, and then work backward from there on all the other deadlines. So without knowing what we think that deadline is going to be, I'm not really sure how to proceed here.
Okay. Well, let me respond, and I appreciate that. And I did not mean to suggest that we are not prepared to come up with that date. But given the different competing interests, we at least wanted to allow the parties to have the discussion as to what that might be. So, for example, and again, I won't speak for staff, but staff took the position or takes the position, I believe, that there needs to be a final decision by July to allow for the surcharge proceeding next year. And if that's the case, then that suggests a potential date. If that's not necessarily the case, there could be a different date. So again, not that the company is not prepared to offer a date, but given the competing interests, I think it's fair to say the company wasn't sure, based on the interests of the parties, what the parties think would be the most appropriate date for that to be.
Okay, all right. So it sounds like Qwest is flexible.
Yeah, absolutely. Completely flexible. I just want to be clear. We didn't want to come in and try to dictate a schedule. And in fact, I let the parties know within reason, the company's prepared to live with whatever schedule the parties agree in your own orders.
Okay, great. That's very helpful to know. Let me then, so I think the first thing I'd like to hear from everybody on is what you all think the new effective date for an amended advice letter should be. And considering the new effective date, typically, basically what would happen with that date is that the commission's initial 120-day suspension would still apply to that date. And then I would just add 130 days from there. So it would still be a total of 250 days. So with that in mind, let me start by hearing from staff on your position on that.
Well, thanks, Your Honor. We didn't have a set effective date that we had in mind. Our goal is simply, if this is intended to be reflected, whatever decision is made in this case is intended to be reflected in the 2026 surcharge proceeding, which that would begin in July, then generally wrap up by October, that we probably need to have everything finalized, by the end of August, if possible. So effective date that would get us a deadline around that time would probably be best.
And let me also just clarify, my reference to a final commission decision is to the commission's decision on any exceptions that are filed. That's considered the final commission decision for the statute's purposes. I think there can be R that can be filed from there, but the final, decision would be a decision on exceptions. So I know that I have seen in proceedings past more than one round of R, and so I can't say how much longer after that final decision is issued before there might be some other decision, whether it be that the final decision stands or that there are any changes based on R. So I'm not really able to plan around that. We can certainly try to say final decision by X date and then consider like a 30 days after that in the event of R, if that makes sense for all of you. And if we were to do that and we're looking at the end of August, then I think we're looking at trying to have a new effective date that would be by the end of July, based on what you just explained, or at least from staff's thinking. Does that sum it up correctly, or?
Yeah, I think so. I mean, and other parties can correct me if I'm wrong. We kind of just went through this with the improvement plan proceeding, and we tried to get through that and have something done by the end of August. So I'm just basing it off that experience. But yeah, if we could have something done by the end of July, I think that would work out well and would be able to be incorporated into the surcharge proceeding.
Give me a moment here. I want to just do some calculations to see if I could figure out what that amended advice letter date would be if we're aiming for a decision by the end of August. Okay, so if we had an amended advice letter date of November 25th, the final effect, the new effective date, we would add 250 days to that. And that would get us, let me see. Every time I enter a date here, I'm ending up on a Saturday deadline, which an advice letter can go in effect on a Saturday. It's just a commission decision doesn't issue on a Saturday. So it would end up rolling over So hold on just one second. Okay, so if we have a November 23rd effective date and we add 250 for the new effective date that's extended, then we would have the effective date being July 31st, once obviously it's been suspended. So that would be the deadline by which essentially the commission would issue the final decision, which would be a decision on any exceptions that are filed. And so we could base everything back from that. All right, so let me hear from Qwest on that being a new effect. Actually, let me start with staff since you're already unmuted. How does that look for staff?
I think we could make that work.
Okay,
It will give the commission enough time. I was doing 250 from the end of August, and that was December 24th. I'm not sure about backdating the effective date now that we're already past November.
yeah, that is a good point. I don't think I've done that before, and I have not had the opportunity to do any research on whether that would be okay, or I mean, it might be perfectly fine, but we maybe want to be a little bit safer and pick a date that's hasn't already passed, because I wouldn't have had the opportunity to suspend it in the past. So I guess it just depends on how quickly Qwest could get something filed. Mr. Corbetta, how quickly do you think you could get an amended advice letter filed? Because if you get it filed within a day, we could pick, you know, the day after you file it or within a few days of when you file it.
Yeah,
I might need a few days to get a decision out the door.
sure. Actually, I would ask Mr. Kunkelman, who is closer to that process than I am.
Hi, good afternoon, Your Honor. Yeah, I think we could do this in a day or two would be fine. And just and then we can figure out what date. Because we would, if we file, let's just say we file this, you know, tomorrow. Can we put it a December 10th date on it, or would we still have to put another 30-day after that since it's proposing rate increases or new rates, I guess?
No, well, the only thing that I'm really looking at is needing enough time for my decision suspending these dates to go out. And I have tried to get ahead of the ball on this. I've got a draft ready to go. It won't take me long, but I do need the dates and everything to, you know, insert for our schedule. And it might, unfortunately, it can take a couple of days once I've even finished the decision for it to get processed and out the door. And I don't control how long that takes. I can't imagine it getting out before Friday. Friday might be, if I'm lucky, it could get out on Friday if you guys file it pretty early tomorrow. So if you file it tomorrow, I would need an effective date no sooner than December 12th, just to make sure I can get the decision out, suspending the date before the date comes and goes. Otherwise, we're in the same situation where I'm going to have to figure out whether I can legally suspend a date.
Sure, that makes sense. Okay. Yeah, we could put that date out, you know, 1 week maybe. I guess the issue is I just want to make sure that the process of the intake of this wouldn't get automatically kicked back to us because staff would say that the date was incorrect. We didn't give enough time. That's all. Just want to make sure we're not going to run into that strange anomaly. But we could say we could put it. I could do it tomorrow. I think I could get this tomorrow, and we could just put the 17th on it. That gives.
Okay.
Hopefully hope it doesn't cause any procedural trouble with just the intake of the advice letter itself.
Yeah, I'm not sure what you mean by the intake of it. It would be
Well-
filed in this proceeding.
Oh, just file it in the proceeding.
Yes, you're not
Okay.
going to do a new one.
I got you.
You're going to file it in this
My
proceeding.
misunderstanding.
No, that's okay. I understand. There are definitely directions on advice letters, filing them in new proceedings. We have this one already up and going, so it would be filed in this case.
Thank you.
All right, so with December, if we do December 17th, just calculate out what the deadline would be. And we can also plan to try to come up with a procedural schedule that doesn't take up that full amount of time. If you're looking to try to get a commission decision out by the end of August. So, but I still need to know what the full amount of time is when looking at this. So hold on just one second. It would be August 24th. So okay. So if we're looking at trying to set up a timeline that would get a decision out, that the commission could get a decision out before the end of August, I would want to get my decision out earlier. And I would want to get my decision out sometime by the end of May. That should give enough time hopefully enough time for everything after my decision is issued. So I'd be looking at working backward from there and figuring out the rest of the schedule. I think we've got Mr. Benkert raising a hand. Do you have something you want to add to the conversation?
I do. As I understand it, these services will not actually be taken by any customers until 2026 when the surcharge proceeds distribution is available to pay for them. And so we don't need to be real tight on the other end. And we need the decision to be final by the time the PUC would adopt the surcharge amount for 2026, which would be for October 1st. So we might have a little bit of latitude.
Okay. So this idea of having it done by the end of August is not necessarily firm. Am I understanding that correctly?
I believe in this surcharge proceeding, the commission decided the exceptions a few days before October 1st. But I don't want to push it too tight. But I think we have more flexibility and don't have to be nailing it down exactly.
Okay. All right, Mr. Kunkelman, you are represented by counsel, so really it's your attorney that needs to speak on your behalf.
Right. Well,
Okay,
so,
I'll tell him my message.
Okay.
yeah, thank you, Your Honor. I appreciate that. I think that Mr. Kunkelman is responsible for implementing the filing, and it might be more efficient if Your Honor would recognize him just to address the specific issue that Mr. Benkert raised.
Okay. All right, Mr. Kunkelman, I'll if you want to go ahead and respond to that, I'll allow it this one time.
I appreciate that, Your Honor. My comment that I wanted to make was, while we realize that this needs to coincide with funding when and if it becomes a required purchase. However, at this time, we've offered that most of this will be on a voluntary basis in perpetuity. And the item that we are currently seeking to have be a required element would not be required for another year after the effective date of the tariff. So while we appreciate that we're not under a time constraint to get funding for required services, we as a provider of these services would like to offer them to our customers should they be interested in taking them. And we do have some customers who have expressed that interest to us. That was all I wanted to add. Thank you.
Okay. Mr. Benkert, did you have anything more to add? I see your hand is still raised. I didn't know if you had anything in addition.
No, I did not. I just forgot to lower it.
Okay. Does anybody else want to chime in on this? All right. Well, it seems that getting a final decision by the end of August would probably be best. It would be playing it safe. It would put everybody in a better position, including the commission. So if we're to do that, then my decision would need to go out earlier than it normally would to give time for the final decision on exceptions, and then possibly time for, triple R, which I don't normally take triple R into account when coming up with these timeframes, because you just really never know what's going to happen. And it does tighten things down quite a bit. And if I were to take triple R into account, then I would have to have a decision issued by the end of May, which would mean we would need to have a hearing in April, which honestly doesn't add a whole lot more time for all of you to litigate your case. So perhaps, I'm just going to, maybe I just forget about triple R and I just look at the final decision and we move backward from there. And if we do that, then I would need to have my decision out by, about June 20th, around that time frame. And with that in mind, let me just back that up to when I think a hearing would need to be held. So I would want to have the hearing concluded by May 6th. So let me just check in with all of you. Is that something you think that would provide enough time for all of you to litigate and get ready for a hearing? I'll start with Qwest.
Yes.
Okay. Staff?
Yes, it would.
All right, let's hear from the BED authorities.
Yes, we'll do what we have to.
Okay, and from LIDA? and Coca?
Your Honor, that would work. I just do want to point out, I have a witness who would be unavailable April 29th through May 10th. But the May 6th conclusion, with that qualification would work.
Would your witness be able to appear remotely if needed?
Only if absolutely needed, but it is a major conflict. I wouldn't plan around it, Your Honor. I'm sure I could work with other witnesses. as
Okay. Because pushing it I can't do it past May 10th. I mean, that's,
Okay.
and I doubt everybody is going to agree to a hearing before April 29th. I think everybody's going to probably want as much time as they can get. So we'll just have to find a way to work around that. What about the AAJ authorities?
That timing works for us, Your Honor.
Okay, so let's start then by, I'm going to look at the commission's calendar. And I think it's best to start with the hearing date first, and then we move back with Deb from there for deadlines. So. Okay, it looks like we can hold the hearing on May 6th. I could also hold it the day before, May 5th. And then that prior Thursday, May 1st and May 2nd, those dates are also available. I don't know how many days you all think you need. That's why I'm letting you know what numerous days. So from Qwest, how many days do you think will need for this hearing?
Well, I'm going to throw out there 1 day. I don't know that this is more complicated than that.
And do you have any preference as to the dates I just provided, which are May 1st, 2nd, 5th, and 6th?
Oops, sorry. I don't. May I just confer with Mr. Kunkelman again for witness purposes?
Sure. And meanwhile, anybody else who might need to confer with folks, please go ahead and do that now.
All right, Your Honor. If I still have the floor, I think Mr. Kunkelman is saying we'll work with whatever Your Honor comes up with.
Any of those dates work for you?
Yes.
Okay. All right. So just to make it easy to check in with everybody else, please use the raise a hand feature. If you have an issue with any of those dates, or you want to state a preference as to any of those dates I've just provided. And if you don't, then I'm going to assume you are all okay with these dates, and I will just pick one. And I'm just going to give it a minute because I know you all were trying to get a hold of your clients too. Mr. Benkert?
I'll note that May 5th gives us the most time, and if I don't know if we would need to go over to the 6th, but we might reserve that just in case.
Okay.
I don't think it should take more than 1 day.
All right. Mr. Cox?
Thank you. Our witness does have a conflict on May 6th, so that's probably not going to work. Half of our council team has another hearing starting on the 5th. We could work around it if necessary. I would think even if it's 1 day, it sounds like we hope it's 1 day. We may want to schedule 2 days just in case. So the week before, the week of April 28th, I think would be preferable to us.
Well, I mean, if we did do it on the 28th, we might avoid that other conflict we just discussed. I just don't know, how willing the parties are to give up that much more time. The 28th is open. I could set it for the 28th, and we can reserve some time for the 29th as well if we needed it. Does anybody have any position you want to share on that, whether you're available, whether you're willing, whether you think that's a problem? I'll just ask anybody who would like to speak up on that to just go ahead and raise a hand, and then I'll hear from you. And if you don't, I'm going to assume that plan works.
And just to be clear, Your Honor, I wasn't necessarily advocating for the 28th in particular, you know, whether it's the 29th, 30th, 1st, you know, we can make those work.
Does Qwest have any preferences?
Well, again, we'll make them work. Let me just suggest let's see, April 28th is a Monday, maybe 29th, Tuesday might be preferable. We could pick that date if staff would be okay with that.
And that date is open. But it would be more difficult to reserve back-to-back days because the 30th is a little bit jammed in terms of the commission's schedule. So if we wanted to reserve more than one day to play it safe, it would be, and we wanted to start on the 29th, it would be the 29th and then May 1st.
I think that's fine. I'm fairly confident we can get this done in one day. So I will say for Qwest, that's acceptable.
Okay, thank you. Does anybody else want to state a position on this? And if you don't, I'm going to assume that means you're fine with those dates. Yes, Ms. Oldemeyer.
Based on travel, it may be April 28th might be the better date for LIDA and CCOA.
Okay. Yes, I think you said you had a witness that was going to be unavailable from the 29th. And if that's their travel date, we can't really work around them traveling. So I think maybe you're right. Maybe we should do the 28th and reserve some time on the 29th. And if your witness, if your witness does need to testify, we can, if necessary, call your witness out of order so that we can do that on the 28th.
Okay, and Your Honor, I did just hear from that witness, and honestly, that whole week is bad. I thought Monday might have been a travel day, but so no preference the week of the 28th, which dates other counsel choose. We will make anything that week work.
Is your witness, is your witness not traveling on the 28th or the 29th?
We will find a different witness.
Okay.
We will need to, yeah.
Okay, all right. Okay, a lot of back and forth on these days. No wonder why you all weren't able to work it out beforehand.
May I, Your Honor?
Sure.
Yeah, but you can see how amicable it's been, right? It's certainly not adversarial. The only reason I suggested the 29th is that having a hearing on a Monday sometimes poses challenges. So that's why I suggest the 29th and the 1st. But quite honestly, whatever dates you choose that week is fine with us.
The 29th and the 1st are fine by me. Who likes to have an evidentiary hearing on a Monday? Not even me. So I hear you on that. So let's go with those dates. I'm going to make a note of them right now. And if anybody in the meanwhile has any issues, please let me know immediately. Otherwise, we're going to move on and plan everything around those dates and then have to start over. All right, I'll just note for the record that nobody has spoken up or used the raise the hand feature to indicate they want to say anything. The next thing I want to determine is if there is a preference as to the manner in which the hearing should be held, whether it should be fully remote, fully in person, or a combination of the two. Mr. Corbetta?
I will state the company always has a preference for in-person hearings, but I understand that others may differ. So again, we're not going to fight that one, but our preference is an in-person hearing.
Okay. And does anybody have any witnesses who are out of state who may need to appear from remote locations? Because if there is at least one of those, I'm inclined to hold this as a hybrid hearing. Ms. Oldemeyer?
Your Honor, for that reason, we would request a hybrid hearing, given that the potential witnesses could be anywhere within the state of Colorado. And
Okay.
I don't know which our witness will be yet.
Right, yeah. All right, I think what we'll do is we'll hold it as a hybrid hearing, which means that anybody who wants to will appear in person at the commission's offices. Witnesses and counsel can appear from remote locations. The only rule that I have is that we need to have at least one party appear in person. Because if everybody decides they want to appear remotely, it doesn't make any sense to, for me to be in a courtroom by myself, which is what will happen. I'll be in the hearing room by myself. So what I'm going to do, since we're setting this as a hybrid hearing, is that I will also establish a deadline about 2 weeks before the hearing date for Qwest to make a filing in the event that everybody has changed their minds and nobody is going to appear in person. If at least one party will appear in person, Qwest will not have to file anything. I will just assume we're proceeding as planned. You only have to file something if everything has changed. And I will tell you, it does happen. I have parties who adamantly say they want to have an in-person hearing, and then we get up to the hearing and everybody changes their minds. So if everybody changes their minds, then I'll convert it to a fully remote. But the good thing about a hybrid hearing is that it doesn't change any of our procedures. All of the evidence will be presented the same way, whether we're in person or everybody is fully remote. So it's a very easy fix if it needs to be changed later down the line. Okay. All right, now with a first day of hearing starting on April 29th, I would like to hear, let's say, from Qwest about a schedule. In other words, when would you like to get direct testimony filed? Obviously, I want to give Qwest enough time to get that done, and I want to add and make sure there is enough time for answer testimony, rebuttal testimony, and cross answer testimony. Any suggestions from Qwest on?
Well, if I may have a moment, let me look at the schedule that we had initially proposed, which is actually fairly close to this one. Just if I may have a moment.
Sure.
So we had initially proposed a hearing the week of May 12th with direct testimony in early March 7th. So if we're backing 2 months up, I guess that's February, late February for direct testimony. I think generally speaking, we start with direct testimony 2 months as we work through the deadlines. I think that generally is the cycle. So February 27th.
Let's start with that date and we'll see how it works out for all the other deadlines. So with a February 27th direct testimony deadline, we could have answer testimony due about 30 days after that. Hold on, let me just see what that would look like. If we go with that time frame, then I'm kind of looking at rebuttal testimony being the time frame on doing that being a lot shorter. I mean, you'd only have about probably 2 weeks. And then that would also limit the amount of time I would think you all would have to discuss settlement. Usually settlement discussions in earnest don't happen until after answer testimony and sometimes even after rebuttal testimony.
Mhm.
That way everybody knows what everybody's position is and it can be a lot easier to settle. So if we push that direct testimony back to say more like the end of January, that would allow the parties, I think, quite a bit more time to try to resolve their disputes. Mr. Crowbetta, do you think that's doable?
I think it's doable. I think, though, that we would probably rather have, and your point's well taken on settlement, but I think we'd rather have a little more time up front, and we're okay with a little less time for rebuttal.
Okay.
So maybe we could split the difference to mid-February, and appreciating the compressed rebuttal time, which again, we would live with to get a little more time up front.
Okay, so we push it back by about 2 weeks, then direct testimony would be due February 13th. And let me just kind of look ahead from there. We'd have answer testimony due about 30 days after that. And then I could have rebuttal and cross answer testimony due, let's see, about 2 weeks later at the end of March, maybe the very beginning of April. And then that would give you all most of April to work on settlement. Okay, how does that sound? I'm gonna nail down the specifics here in a moment, but I just want to get a general sense from Qwest as to that time frame.
Yes, that's acceptable.
Okay, and for the interveners, a 30-day turnaround on answer testimony, you were all good with that? I'm gonna take silence and nods to mean yes. Okay, so we'll have direct testimony due on February 13th. And just give me a moment, I'm gonna do my little calculations here. Okay, and then I'll have answer testimony due March 17th. Unfortunately, the exact 30 days on that would be a Saturday, so it would fall to that Monday anyway. So we'll just set it for that Monday, the 17th. Okay, and then we'll have rebuttal and cross answer testimony due April 1st, which is 15 days after answer testimony. Next deadline I'm looking to set are for settlement agreements. So I want to hear from the parties on how much time do you think it would be appropriate to file a settlement agreement. And if possible, I want to also have time for settlement testimony, though I know that's not always possible.
May I ask, just for clarification, just so I'm straight so far, we have direct testimony on February 13th, answer testimony on March 17th. And I'm sorry, what day did you say for rebuttal testimony?
Rebuttal and cross answer will be April 1st.
Okay. So if the hearing is on April 29th,
Yeah.
you know, if we have the settlement or proposed settlement agreements, you know, 2 weeks before the hearing, does that give you enough time?
Yeah, that should give me enough time. I want to set a settlement testimony deadline as well, because sometimes when I get the settlement testimony, it really helps me understand things that may not be clear to me in a settlement agreement, and it can therefore make it so that I decide we don't even need a hearing if it's a comprehensive one. Now, I realize if you file your settlement agreement on the 15th, you know, you're not going to have much time before the hearing to do settlement testimony, but I would still like to have a deadline for that. I'm thinking April 21st for settlement testimony. And I'm going to make that a permissive deadline, which means you don't have to file a settlement testimony. It is certainly my preference that you do. All right, how do those timeframes work for everybody? Just use the raise the hand feature if you would like to say something about those timeframes. Okay, so with that in mind, I'm going to set the 21st is going to be a deadline for several things. Any corrections that need to be made to testimonial exhibits will also be due on the 21st. And then any non-testimonial hearing exhibits will need to be filed on the 21st. And that's, sometimes people like to file discovery responses as a, you know, an exhibit in a case. I've seen people try to, you know, submit articles and other public statements. So that's sort of the thing I'm referring to here, things that are not going to be a part of your either testimony or attached to testimony. So this is a separate deadline. And then your exhibit and witness list will be due on that same date, the 21st. The joint witness examination matrix, which is basically where you all list what witnesses you plan to call and how much time you all anticipate using for the witnesses. I'll have that due on the 25th, Friday before the hearing. Pre-hearing motions will be due April 22nd, with responses due April 28th. And then statements of position will be due May 13th. That's 2 weeks after the first day of the hearing, which is really the most amount of time I can give you if I'm going to get a decision out quickly. All right, let me review all these dates, and if anybody has any issues or questions, we can go over those. So to start with, an amended advice letter will be filed hopefully tomorrow with a new effective date of December 17th, which will then be suspended by an additional, a total of 250 days when you count the 120 the commission has already added. The hearing will be on April 29th and May 1st. It will be a hybrid hearing. Direct testimony is due on February 13th. Answer testimony is due on March 17th. Rebuttal and cross-answer testimony is due on April 1st. Stipulations and settlement agreements are due on April 15th. Settlement testimony, which is discretionary, will be due on April 21st. Corrections to testimonial exhibits will be due on April 21st. Non-testimonial exhibits and exhibits and witness lists will all be due on the 21st of April. The joint witness examination matrix will be due on April 25th. Pre-hearing motions will be due on April 22nd with responses due on the 28th. Statements of positions will be due on May 13th. Did I get all of that correct? Does anybody have anything they'd like to add or raise any issues with this timeline? All right, take that silence to mean everybody is on board with this timeline. Are there any agreements the parties have reached relating to discovery that we should put on the record?
Not from Qwest, Your Honor. Thank you.
Okay. What that means is that the commission's rules relating to discovery will apply, and that includes all the timelines. Are there any other issues that we should address before we adjourn the hearing? All right, I'm going to take that silence to mean no. I want to just say thank you to Qwest for being flexible on the timeline and for agreeing to get the amended advice letter filed tomorrow. Doing that will make sure that I can get this decision out before the holidays. As I'm sure you can imagine, we tend to have more limits on our staffing, and it can take a little bit longer to get decisions out, no matter how quickly I work, no matter how fast I jump on these. Sometimes it just will take more time. So I appreciate that, and I will look forward to seeing that filed tomorrow. With that, I think we've addressed everything I've got on my list to address here today. My written decision will memorialize all the rulings that have come out of today's hearing, and will also provide additional procedures on how the hearing is going to be worked, primarily related to the fact that all exhibits are going to have to be presented electronically, which means that marking them and filing them and titling them correctly will be pretty critical. If people don't do it correctly, it can cause us problems during the hearing and a confusing and messy record, which I tend to try to be the guardian of the record. And so I will be on you if you don't do it right. All right. Thank you all for appearing here today. And I think that covers it, and our hearing will now be adjourned.
Thank you, Your Honor.